Our goal today is to talk about some examples of ways that you can get involved in metastatic breast cancer advocacy. We're going to do that using three key issues. But when we talk about cancer advocacy, there's a whole spectrum of ways that people can get involved, whether it's advocating for yourself or advocating on behalf of an organization in the cancer community or sharing information through the media or social media. But today we're really going to focus on legislative advocacy. Now, when I tell people that I'm a cancer rights attorney, I always get kind of a funny look, like people don't know exactly what that is, and that's understandable. Most people don't think of cancer as a legal issue, but just about everything related to a cancer diagnosis can actually be rooted in the law. So whether or not you get access to a particular treatment that's been approved by the Food and Drug Administration is a legal issue. Whether or not your insurance covers that particular treatment is a legal issue. Your access to different types of insurance coverage is a legal issue. Applying for government benefits or being able to take time off work or medical decision-making documents or consumer rights. All of those things are legal issues rooted in the law, even though they're things that we don't necessarily think of as legal issues, like accessing health insurance coverage. But legislative advocacy is also a spectrum. So generally, the first step in engaging in legislative advocacy is passing a law. But then we can actually tweak that law and flesh it out, like flesh out the details about how the law is actually going to work through regulations that are promulgated by the agencies that are responsible for those particular laws and implementing those laws. But then over time, we tend to continue to improve laws. So we can amend it through more legislation, we can pass more regulations. There could be legal cases that flesh out details of the law. And then ultimately, we could scrap a law and start from new. But I think one piece that often gets completely forgotten, both in law schools when they're teaching lawyers about the law and in legislative advocacy efforts, is we can't just pass a law and then not tell anybody about the law. And that seems like a pretty obvious step, but it's one that is horribly forgotten. And I often say if all we needed was a law to solve a problem, we wouldn't need lawyers and we wouldn't need law enforcement. Just passing the law is really only the first step. If we passed all the most amazing advocacy generated laws and didn't tell anyone about them, then no one would actually benefit from those legal protections because they wouldn't know how to enforce their own rights. So this is actually, in my mind, the most important part about what we do as cancer advocates, is making sure that people understand their rights and protections. So there are some key steps to legislative advocacy, including making sure that you are getting educated, both about the advocacy issues that you care about, but also knowing who your elected officials are at the local, state, and federal level, because they are making decisions on a daily basis that impact your daily lives. And you want to learn about those issues. You also kind of want to get the landscape of what else is going on in the cancer advocacy community. See if there are potential collaborators out there or other people who are interested in working on the same issues that you are. But you also, if you want to get involved, don't have to do it on your own. You can join other organizations' advocacy efforts in the cancer community or even outside the cancer community if there are other issues that you care about that also relate to what we do in the cancer advocacy community. And I don't think I can stress enough, probably the most obvious way to get involved, but to vote. We have elections all the time at the state, local, federal levels. And again, those elected officials have a great deal of power over our daily lives. And so it's important to voice your opinion on those elected officials. And then that third step is about sharing what you're learning on these cancer advocacy issues. So at Triage Cancer, we actually provide free education on legal and practical issues related to a cancer diagnosis. And on our website, we sort those issues by topic, but we also sort those issues by location because where you live matters in terms of what you have access to. We have charts of state laws that cover all sorts of topics, from employment to insurance to finances and a whole host of other legal issues. And it is actually a great tool to understand what's available in your state and what's not available in your state, because what's not available might actually show you potential advocacy opportunities in your state. We also host free educational events, including our Triage Cancer conferences. We do have one coming up on May 21st, but this is a full day event that provides some real foundational information on some of the most common legislative advocacy issues related to insurance, employment, disability insurance, and finances. So jumping to our first hot topic of accessing clinical trials. There has been quite a bit of focus in the cancer community for many years about improving access to clinical trials and also trying to address disparities in access to clinical trials. We do have some relatively recent wins related to legislative advocacy when it comes to improving access to clinical trials by lowering the costs that patients have to pay when they decide they want to participate in a clinical trial. So we, through the Affordable Care Act, have private insurance coverage for the routine costs of clinical trials. And the routine costs are things that would have been routine if you'd been getting the standard of care. So things like blood work and imaging scans and office visits, all of the things that would have been paid for by your insurance company if you were getting standard of care has to be covered by your private insurance company if you're getting treatment through a clinical trial. So we got that protection in the Affordable Care Act. If you have Medicare or military or veterans coverage, those protections also exist, just under different laws. But probably the most recent win that I'm going to talk about today was actually, as of January 1st of this year, Medicaid in every state now has to cover the routine costs of participating in clinical trials. And that was something that the advocacy community has been working on for a very long time. And so we're happy to say that now improves access to clinical trials for anyone on Medicaid because it lowers those costs. Now, the other problem is that insurance companies often deny coverage for participating in a clinical trial. They'll claim that it's not medically necessary, or it's investigational or experimental, but that doesn't necessarily mean it's not medically necessary for that particular patient to participate in that clinical trial if it's the best treatment option for them. And so also with the Affordable Care Act, we now have the right to go and file an internal appeal if a private insurance company denies coverage for a clinical trial. But if the insurance company still comes back and says no, we now have the right to an external appeal, meaning you get to go outside of the insurance company to an independent medical review organization, and they will decide whether or not the care that you've been prescribed by your healthcare team is medically necessary. And if they decide that it is, that decision is binding on the insurance company. Now, specifically with private insurance and the external appeals process, we know that since this has been in effect, about 50% of the time across the country, those decisions are being overturned, which means about 50% of the time, insurance companies are getting it wrong. That's pretty significant. And unfortunately, most people are not appealing denials of coverage. And this data shows that just with marketplace plans in 2019, more than 40 million claims were denied. But only 0.2% were appealed, and not even to the external appeals level, just to the internal appeals level. So when we're talking about 40 million claims, on average, 20 million of them would have been overturned, we can estimate. So that means that 20 million claims are people who either didn't get access to the care that they were prescribed by their healthcare team, or they paid for it out of pocket when their insurance company should have paid for it. And so when we're talking about how do we address the financial burden of a cancer diagnosis and improve access to care, making sure that you understand your ability to appeal denials through your health insurance is huge. And we feel so strongly about it at Triage Cancer that we have a whole host of resources to help you navigate the appeals process, regardless of what type of health insurance coverage that you have. So those are available on our website. Now, there's a data point that always shocks me in that fewer than 5% of all cancer patients participate in clinical trials. And that's kind of mind-blowing when we think about the idea that clinical trials are the primary way that we get new treatments or new procedures to implement treatments. Or new ways to detect cancer. And so when such a few number of people are actually participating in clinical trials, there's a whole lot of opportunity to improve participation. Unfortunately, even when people want to participate, there might be reasons you're not allowed to. You might not be eligible for that particular trial. And that might be because they've reached the full number of participants, or you're not the right age or gender, or don't have the right stage of cancer, or maybe you've had prior treatments that make you ineligible for this particular trial. So there might be times where patients want to participate in trials, but they're actually not allowed to. And so that's where we get the expanded access program. So the Food and Drug Administration, which is the federal agency that approves drugs, and we've heard a whole lot about the FDA since COVID. The FDA has a program that's commonly called the Compassionate Use Program, but is officially called the Expanded Access Program. And if it turns out that you are not eligible to participate in a particular trial, you might still be able to get access to a treatment that isn't yet approved by the FDA outside of that trial. There is a process that your doctor would have to go through to get access to this drug, but it is voluntary for the pharmaceutical companies or the company making the treatment that you're trying to access to participate. They can choose whether or not to provide that particular treatment. But I will say, I pulled up some recent data, and of the 9,000 applications that were submitted in a 5-year period, 99% were approved, and 75% of them were approved in just a few days. So even though this is a federal agency process, it is actually one that works and doesn't take a significantly long period of time. And so I've included some links on the data, and if you're interested in it, you can email me and I'd be happy to share additional information, but this is all widely available on the internet. Now, this is an interesting example of where, even though there was a solution to a challenge that patients were experiencing, advocacy efforts at the state and the federal level felt like there was still a problem that needed to be addressed. And so the advocacy efforts were focused on what are referred to as right to try laws. The idea being that patients should have a right to try drugs that would provide treatment for them if no other treatment was available to them. The interesting thing about these right to try laws is that they started to be passed at the state level, but had no actual authority to do anything. It was still voluntary for the companies to participate and didn't require patients actually to get access to the treatment. And it actually took years before the first patient, not even a cancer patient, got access to a treatment through this process. And then a few years later, as we saw this roll out across the country and states passed this legislation, we actually got to a federal law. That was a federal right to try law, which created another process outside of the Food and Drug Administration that is not regulated by the FDA and includes no patient protections, making it voluntary for companies to actually provide treatments to patients. So this does exist, but because it's not regulated by the FDA and there really is very little oversight of this process, the FDA does have a fact sheet about this on their website, but very little data on how this program is actually working for patients. We only have self-reported examples. So this is an example of where there was a huge amount of advocacy effort that didn't actually really improve the existing situation on the ground for patients. So with that, I'm going to turn it over to Erin so that we can take a few questions so far.
Hi, everyone. Yes, so we are going to have two Q&A segments during this program. So this time is a time for you to ask questions around the presentation so far. So really focusing, diving in deep on this issue of accessing clinical trials. So if you have any questions connected to that, please put them in the chat. And then after a few minutes, we're going to go back to Joanna's second presentation where she'll cover the next two hot topics, and we'll have a second Q&A for those as well. So I was really surprised to hear how quickly the FDA expanded access program timeline had been when you presented that data. For the insurance appeal process that you mentioned, how long does that generally take? I can imagine there's variability there, but do you have information about that?
That's a great question. So generally speaking, when we're talking about the external appeals process, it needs to be completed within 45 days from when the external appeal is filed, unless it's for an urgent situation. And that actually only takes 72 hours. And there are a lot of examples when we're talking about cancer care where there is an urgent need to access care and you can't wait that long for an insurance company to make a decision. And so the external appeals process can be very helpful.
Yeah, that's great information, because I can imagining you're waiting for days and weeks for an urgent situation might just be a reason not to attempt the appeal. So that's great. That there is that patient protection, that it has to be dealt with within 45 days, and the urgent option too.
If someone has a situation where they don't even feel like they can wait for the internal appeals process to be decided before filing that urgent external appeal, they can actually be filed at the same time so that the urgent decision happens within 72 hours on both levels at the same time.
And for the FDA expanded access program, or the compassionate use program, how receptive are healthcare providers to this program? Is it well known in your experience, or do you think members of our community have to kind of, in addition to applying, have to kind of educate their healthcare provider team on this option? What's your take on that?
I think, unfortunately, there's a lot of burden on patients to be educating healthcare professionals about a lot. And if you happen to be talking to your healthcare professional and asking about your options related to clinical trials, if you feel like they don't, if they aren't familiar with those options, then asking for referrals to other providers who might be able to explain those options. And then certainly if you find a trial that your healthcare team is saying it's appropriate for you, but you're not eligible for that trial and they don't mention the compassionate use program, then absolutely bringing it up with them to see if it's an option is important.
Great, thank you. We do have a question that says, what are the best methods that one can advocate for clinical trials if you're living in a rural area? And this person is specifically passionate about access for the Latinx community, and perhaps the Latinx community living in rural area. Do you have any comments on that, and kind of access for those that might have to travel a really long time to access some of these clinical trial sites?
So there's a lot of potential ways to advocate around these topics, depending on what issue you think is most important. So if it's about making sure that there is more information about clinical trial options in different languages, or if it's about changing the rules so that companies who are hosting trials can reimburse patients for some of those extra costs that insurance doesn't cover, like transportation to participate in the trial, or lodging if you have to stay overnight. So there are some efforts to make that happen. Nothing has been sort of successful to this point, but those are some of the things that have been talked about for a long time to make it easier for patients to participate in trials.
Great. Yes, I mean, it's great to have some of the costs covered under those insurance companies and the recent Medicaid win. But I'm glad you mentioned all the additional costs, because that was a part of the conversation yesterday in the keynote. That was really an active part.
We spend a lot of time talking about that, especially if you are needing to travel or if it's the type of trial where you need to go into a healthcare facility more often. What does that mean in terms of taking time off work? Or do you have minor children that you have to arrange childcare for? Or are you caring for aging parents? There are some other kind of daily life things that can be made more challenging by participating in some trials. But often there are resources to help people, but you have to ask for them. And so we always encourage people to talk to their healthcare team about those added costs that might come up.
And do you have any suggestions for someone that really wants to advocate for this issue in their community? So they're not needing it for themselves, but really want to see change for the community. Is there an organization or space that you would go that they would recommend, or a piece of legislation that's going on, something like that, that they could connect with that would help advance this issue of access to clinical trials?
I would say the first step in engaging in advocacy around an issue that someone cares about is seeing what already is going on. So, is there already legislation, and are there organizations that are trying to advocate around a cause? So, in the cancer community, looking to see what other organizations who engage in advocacy are saying about that issue. And at triagecancer.org/advocacy, we do have a list of the organizations that are engaging in cancer advocacy efforts. So you can take a look at those organizations to see what their priorities are for that year. And then going and doing some research on the legislative issues to see if there are bills that currently are out there. So you can go to congress.gov and search by the term clinical trials and see if there is legislation pending on those particular issues.
Great. Thanks, Joanna. So I don't see any additional questions focusing on clinical trials. For those that have submitted questions on other topics, we will have time to address them in the next segment of the Q&A after Joanna's next presentation.
Thanks, Erin. So our second hot topic is the issue around surprise bills. And it's important to understand some key terms first before we get to the topic of surprise bills. And the first term is understanding what it means when your providers are in network or out of network. Most of us have a health insurance policy that has a specific list of providers who they contract with to provide care to you. And the providers who have contracted with your insurance company are referred to as in-network providers. They're in the insurance company's network. If you want to go to a provider that's outside of that network, generally you're going to pay a lot more for that care, or maybe have to pay for all of that care out of pocket. And insurance companies agree with those providers that they will pay an allowed amount or a contracted amount. So unfortunately, when we're talking about health insurance terms, it just makes it all that more confusing when there's lots of terms that mean the same thing. So allowed or contracted amount means the same thing. And once they've agreed to accept that allowed amount, that's what they have to take as payment from the insurance company for the care that they've provided you. Now, I often say that going to the news is the worst place to go for information about how our healthcare system works, because the news often uses terms interchangeably that don't actually mean the same thing. And surprise billing and balance billing is a good example of this. So surprise billing is when you need to have surgery and you've picked a surgeon that is in your insurance company's network. You've picked a hospital to have the surgery that's in network, and you go and you have the surgery. And then you get home and you get a surprise bill from the anesthesiologist who participated in your surgery. And it turns out that anesthesiologist was actually not in your insurance company's network. And so now you're responsible for paying thousands of dollars out of pocket because you didn't know that your anesthesiologist was going to be out of network. So that's a surprise bill. And this has become such a problem over the last few years that many states have passed laws requiring insurance companies to treat those out-of-network providers who are a surprise as if they were in network. Many states only have this protection for emergency room visits because we can't usually control where we go for the emergency room. And so those providers are likely to be out of network for you. And therefore, your insurance company has to treat them as if they're in network. So we do have a list of these state laws on our website around surprise billing. Now, balance billing is when you know that you are going to a provider that is out of network, and maybe that provider is going to charge you $100 for that service. And your insurance company will actually pay 50% if you're going to go to an out of network provider. So your insurance company pays 50% of that $100 bill, and then the provider actually bills you for the balance of the bill. So the insurance company pays $50 and you're responsible for the remaining $50 because it was an out of network provider. If that provider were in network or a preferred provider, they are not allowed to balance bill you. So if the provider charges you $100 and the allowed amount is $70, that provider can't charge you the remaining $30 for that service. They actually have to eat the $30 because they agreed to accept the allowed amount of $70 from the insurance company. So it's important to know that if you are choosing to go out of network, you can be balance billed, but if you're going to an in-network provider, they cannot balance bill you. So we now have, thanks to some cancer advocacy efforts, the No Surprises Act, which is a new federal law that went into effect January 1st of this year, which requires private insurance companies to treat surprise bills as if they're from in-network providers. So if that anesthesiologist sends you the surprise bill, your insurance company has to treat the anesthesiologist as if they were an in-network provider. Now, this is actually kind of interesting because it's a very new law and the regulations have been trickling out, and there's been some cases arguing about the regulations, but those have been on the provider side where the providers and the insurance companies are still arguing over how to figure out what's the fair rate to pay the providers. From the patient perspective, it's settled. It's no longer the patient's problem. The insurance company and the provider have to work it out. It's not the patient that is responsible for that surprise bill. Now, again, just because we have a brand new law doesn't mean that it's all going to get implemented exactly the way that it should, or that insurance companies and providers are going to follow the new rules. So if it turns out that you do get a surprise bill at the U.S. Department of Health and Human Services, there is now a No Surprises help desk where you can call or you can go online and actually file a complaint saying that you've received a surprise bill and it needs to be worked out, and they will actually help you do that. Now, there are some pros and cons to this new piece of legislation. It does apply to emergency medical services and non-emergency. So if you have that planned surgery, it still applies in that circumstance. It also covers air ambulances, where it prevents patients from receiving huge surprise bills. But unfortunately, it does not cover ground ambulances, which is a place where we know patients are also getting huge surprise bills. So that was one loophole that was carved out of the bill because of political compromise. So some other details around the bill that we want patients to be aware of, because as people start to use these protections, we know that they're going to face some of these challenges. Unfortunately, if you do go to an out-of-network provider, an out-of-network provider can actually ask you to waive your NSA rights if you're not getting emergency care. And if you say, I'm not going to waive my rights, then the provider can say, well, then we're not going to provide the care. So in that circumstance, if you want to go to an out-of-network provider and you know you're going to an out-of-network provider, you have to accept the fact that your insurance company might not pay for all of that care. Out-of-network providers are not allowed to ask you to waive your rights if you're getting anesthesiology, pathology, or diagnostic services, or when an out-of-network provider is the only option. So if you're in a rural area and that anesthesiologist is the only one available, they can't make you waive your rights to have these protections where your insurance company is going to treat them as in-network. Now, if you are uninsured or you're choosing not to use your health insurance coverage and you're going to a provider actually has to provide you with a good faith estimate of the cost of your care ahead of time so that you aren't facing those surprise bills later on. And then once you actually get the bill, if it exceeds the estimate by more than $400, you can actually file a dispute on that same phone number or website with the Department of Health and Human Services. So it layers in some more consumer protections, but we are all waiting to see how this actually plays out as patients start to get care and then receive bills for that care. So moving on to the third hot topic, we have two long-term disability programs in the United States that are run by the Social Security Administration. There is Social Security Disability Insurance, and there is Supplemental Security Income. So there is SSDI and SSI. SSDI is the program that is based on your work history. So it's based on the fact that you have worked throughout your career and paid into the Social Security retirement system. And effectively, you're getting access to your retirement benefits early if you're unable to work because of a medical condition. Now, what someone gets each month from Social Security is going to be based on what you've earned throughout your work history. But the most that you can get this year per month is $3,345. With SSDI, once you've been approved for benefits and they say that you are eligible to start receiving those cash benefits, you actually have to wait 5 full months before you actually get your first payment from Social Security Disability Insurance. And I often say that there is literally nothing else that we talk about that makes less sense in terms of a benefit or a protection. Because here we have individuals who are unable to work because of a medical condition, and we're not going to provide any help for 5 full months, and then we'll provide them with their first cash payment. And that just doesn't make sense in terms of being able to pay bills and pay for access to health insurance coverage. So this 5-month waiting period creates a lot of very practical problems for patients. In addition to the 5-month waiting period for the SSDI cash benefits to begin, SSDI is tied to Medicare. So once you've been receiving SSDI for 2 full years, then you can get access to Medicare, which is the federal health insurance program for individuals who are over the age of 65 or have been receiving SSDI for 2 full years. Now, again, this is a situation where if someone has a serious medical condition enough to qualify them for SSDI, chances are they're going to need some type of health care. And so delaying access to a program that could provide access to that health care also doesn't make a whole lot of sense. And so we in the advocacy community have been working for many years to try to eliminate these waiting periods. Most recently, in 2019, there was the Stop the Wait Act, which eliminated the 5-month waiting period for SSDI and the 24-month waiting period for Medicare. It never got out of committee in Congress, and so it actually, what we refer to as died in committee in 2021 when we got a new Congress. And then actually, we've been waiting for more than a year for new legislation to be introduced into this Congress. And that was just introduced in February of this year. But it already has 78 co-sponsors in the House for HR 6583. And then there is also a Senate version, 3575. But that only has 8 senators out of 100 so far who have actually co-sponsored that legislation. And in addition to this legislation that would remove those waiting periods for everyone who qualifies for SSDI, there is also a bill that is specific to individuals with metastatic breast cancer called the Metastatic Breast Cancer Access to Care Act, which would eliminate those waiting periods specifically for an individual with metastatic breast cancer. So since spring of last year, there have actually been no action on either of those bills at the Senate or the House levels. So there is an advocacy opportunity on the table here for you to contact your elected officials to ask them to co-sponsor this legislation, or ask them for a hearing to actually hear about these issues and how these waiting periods cause very practical problems for individuals with medical conditions that entitle them to SSDI. And so if this is an issue that you care about, there are a lot of ways that you can advocate for these pieces of legislation specifically. So Erin, I will turn it back over to you.
Hi, thank you for those additional covering of both of those topics in depth. We had our surprise bill conversation and then the SSDI waiting period. So we do have some questions I wanted to share from our audience. So one question, when you're just speaking about the bills, this is connected to this. How many co-sponsors are typically needed for there to be movement on a bill? Is there?
That's a great question, and there isn't an answer to it. I would say the more co-sponsors, the more likely it is for a bill to get a hearing. And ultimately, it makes it a lot easier when it comes up for a vote because those individuals are more likely to vote for the laws that they are co-sponsoring.
Great. Can you, a little bit more information about SSDI, some practical questions here. So is SSDI taxable, but the benefits taxable for individuals?
It can be based on your overall household income. So if you are married, for example, and your spouse works and you're receiving SSDI, at some level, you would actually have to pay taxes on your SSDI benefits up to a certain amount. If you're receiving supplemental security income or SSI, those benefits are not taxable. And then you always have to pay attention to how your state treats disability benefits versus the federal law. So that's a state by state situation.
Always complicated. What's your advice for someone that wants to kind of tease out what that situation could be for themselves? Where should they start to get that information of what they could potentially qualify for if they were to go down that avenue?
If someone is looking to see if they qualify for SSDI based on your work history, you can actually look that information up on your Social Security statement. So we used to get mailed our Social Security statement every year, and they don't do that anymore. So you can create an account at ssa.gov and look up your Social Security statement and see what you're going to make when you eventually retire. But you can also see exactly what you would make if you were to file for SSDI this year. And then it would tell you on that page whether or not you qualified for benefits, if you were eligible for benefits, and then you actually have to apply and show how your medical condition is keeping you from being able to work. That said, if anyone has questions about this process, you can definitely call us at Triage Cancer, or actually fill out a form at triagecancer.org/get-help, which is how you can sign up for our legal and financial navigation program to talk to one of our staff attorneys for free.
Great. What an amazing program. Thanks. Can you receive SSI and SSDI at the same time?
You can. SSI isn't based on your work history. It's based on having a low income and a low resource level, meaning your assets. So generally when someone applies for SSI, they will also check to see if you're eligible for SSDI. It is possible that you could start receiving your SSI benefits right away, and then that would actually carry you through the 5-month waiting period before your SSDI benefits actually kick in. The for most people, the amount of their SSDI benefit actually kicks them out of income eligibility for SSI. So at that point, their SSI benefits would stop. But it is possible where if you've maybe only worked part-time through your career, the amount of your SSDI benefit could still be low enough where you could also still qualify for SSI at the same time. So you could potentially get both of those.
Gotcha. And does SSDI require 100% disability where you completely cannot work, or you can work but just a little, want to reduce, can't take on a full-time work? How is that assessed?
So SSDI and the way it looks at disability is different than when we're talking about maybe a private union-based disability program or even workers' compensation. There isn't really such thing as like partial or full disability. It is looking at the fact that you are unable to work because of your medical condition, and you have a medical condition that is expected to last at least a year or longer. And it really is an incredibly high standard of disability. But I will say that someone with metastatic breast cancer is much more likely to qualify for SSDI than perhaps some other types of cancers or even other stages. And so if someone has metastatic breast cancer, they're more likely to get past that first stage of showing that they have a medical condition. But if someone is still working, it is very difficult to qualify for disability benefits because there is a step-by-step sequential process that they go through to decide if you qualify. And the first question is, are you working? And if you answer yes to that question, you automatically get kicked out. But there are some examples of where you might be working today, but 3 weeks from now or a month from now, you actually won't be able to work anymore. And you can explain that in the application. But the first question says, are you working and earning under $1,350 a month for this year in 2022? And if you're earning under that amount each month, you're not actually working according to the Social Security Administration. So that's a situation where you could be working a little and earning under that amount and still potentially qualify for disability benefits. But it creates a practical catch-22 where you're saying you're unable to work because of your medical condition, but you're still working. So you're going to have to explain practically why that is.
So you were encouraging folks that are in this session to contact their legislators to co-sponsor or advance the bills around the SSDI waiting periods and Medicare waiting periods. Can you tell us, someone's asking to hear a little, and you also encouraged contacting legislators about bringing those bills to hearings and trying to build momentum. Someone is asking kind of, can you tell us more about how to ask for more hearing or attention? Kind of what does that mean? What is a hearing for a bill? More information there.
Sure. So anytime you want a legislator to vote yes or no on a particular piece of legislation, it's actually pretty easy to reach out to them. You can call their office in DC, usually DC and not the district office, just because the DC staff is focusing on those legislative issues. And whoever answers the phone, you can say first your name, second, that you are a constituent, which is the most important part of that conversation, because they are going to pay more attention to what you have to say because you are a constituent. And then say, I would really like for the senator or the representative to vote yes or no on X piece of legislation. And really, that's all you have to say. And they might ask for your address or your phone number just so that they can verify that you're in their actual district. And that's it. You can hang up. So it could be a 30-second phone call, but they track that information. And it sometimes can make the difference in whether or not someone will support or oppose a piece of legislation based on the calls. You can also email them or still fax them. If you do write them a letter and mail it, know that it could take weeks to get through the actual postal process because Congress still tests all mail for anthrax. So it goes through kind of a lengthy process to physically get there. So it's much faster to call or email or even fax your elected official for those of us that still use fax machines. But in terms of the hearing, you could say the same thing. I am supportive of this piece of legislation, and there hasn't been any movement in a year, and I would like to see you ask for a hearing on this particular topic. Hearings are where they discuss bills. So once a bill has been assigned to a committee, so it might be, for example, in the US House of Representatives, the Energy and Commerce Committee actually hears health insurance related legislation. So if it went to that committee, you could write directly to the chair of that committee saying, we hope you would actually schedule a hearing for this bill. Or you could ask your own elected official to ask the chair for a hearing. And in that hearing, they're going to ask for experts to talk about the pros and cons of that particular legislation, or they might ask for patients to come and share their story and their experience. So hearings are a very important part of the process of bills getting through Congress or a state legislature.
So we have someone in this session who lives in DC and doesn't have voting representation. So I wondered we were wondering what your suggestions were for that person, or maybe people that live in U.S. territories. How can people that don't have don't live in states, don't have access to their state legislators, how can they get involved in legislative advocacy? What's your advice there?
That's a good question and unfortunate. And I would say if you are in DC, Congresswoman Eleanor Holmes Norton is a very strong advocate for the cancer community, actually. And so even though she doesn't have a vote, she has a voice and she has relationships with other elected officials and has the ability to help educate them on how residents of DC are being affected by a particular lack of regulation or proposed legislation. So it's still worth engaging in those conversations. I think also partnering with existing cancer organizations and their advocacy efforts helps, because when they host lobby days or are engaging elected officials, they're bringing groups of individuals to those meetings. And so you can still be involved in those efforts, even if you are in a territory or in DC.
Thank you. So we had someone who wants to clarify about working if you're getting SSDI. Do you think it's risky to be working part-time? They share that they're worried that it may trigger a more thorough review of their medical situation if they are working that limited part-time amount.
So there is a difference between working when you are first applying for disability versus once you've been receiving disability benefits and then are trying to go back to work. There are different rules that apply and different threshold amounts. So if you are feeling that you are able to work part-time once you've been receiving benefits, it's very important that you report that to Social Security, because if you don't, and they find out that you're working, they can take away your benefits entirely. And there is a process that they have called work incentives to actually help people work part-time while still receiving benefits.
Right. So we did get a few questions that weren't focused on the topics that we covered, but I wondered if you could address this one. It's talking. We know that there's been a lot of changes around telemedicine rules and laws that were brought on with the pandemic. This person is asking if physicians are allowed to give results to patients virtually if they're not practicing in the patient's state. Travel, can be. Telemedicine allowed to opened up a lot of that and reduced the travel expenses for that. So what is the status of kind of those telemedicine or telehealth rules and the state restrictions for that?
So that's a very complicated question because one, it depends on the type of insurance that you have. Two, it depends on the type of provider and their professional rules about being able to practice across state lines if they're not licensed in another state. And then you layer on top of both of those things special rules as a result of the pandemic and a public health emergency. So that is an incredibly fluid thing at the moment. We're seeing many insurance companies roll back some of the telehealth exceptions that they made. And the public health emergency at this point is expected to end at the end of July. We are waiting momentarily to find out if that's going to be extended again because the federal or the president has said they won't they will give everybody 60 days notice before the emergency designation ends. So if the designation is supposed to end on July 31st, we're coming up on 60 days out from that. So really end of April, we're expecting to know if they're going to extend that again or not. And that's going to affect whether or not telehealth exceptions will continue for some, but it's still left most private insurance companies the ability to decide for themselves how they were going to handle telehealth.
Another question about SSDI. How long after you've been diagnosed with cancer can you apply for SSDI? This person is waiting, more than 5 years too long for that benefit.
So there isn't a specific time frame of when you have to wait to apply. And especially if you have been recently diagnosed with metastatic breast cancer and feel like you're unable to work moving forward, apply as soon as you realize that you aren't going to be able to work anymore, because the process can take many months for approval. And then you also have that 5-month waiting period for SSDI. So you don't want to delay that. But every single day I'm speaking in sessions where people don't know that these benefits exist and might have been out of work for years and then go to apply. So it is possible at that point to apply. There's no end point on when you have to apply for disability benefits with Social Security. So it's worth finding out sooner rather than later if you qualify. Social Security will also provide retroactive payments up to a year if your disability began, according to them, at least a year before you applied. So if you want more understanding about the timing of when benefits begin and when you start receiving payments and when you become eligible for Medicare, we actually have a quick guide on our website to the timing of Medicare and SSDI benefits.
Well, thank you so much, Joanna, for this really informative conversation. I'm always blown away by all of the knowledge and the breadth and the depth of knowledge that you have and are always sharing with the cancer community. You're such a great resource for everyone, as is your organization, Triage Cancer. So I'm going to bring back on Jamel, who's going to, I think, ask a final question and then close out today's session.
Yeah, I just want to say I appreciate you so much, Joanna, because I know you're a partner of the Chrysalis Initiative and your resources support us, and we learn so much from you as well. But I'm just struck by how most of the way that we strategize and move forward with a lot of these activities is very incremental. It's kind of just slow, methodic improvements on what we can improve in the system. But I'm also struck by how a lot of these challenges, in particular with the racial disparities that we see in cancer care across the board, are very similar to the inequities that we saw in maternal health that we still see, and how now there's comprehensive packages and legislation that's tied to accountability and payers, and really adding some more teeth to the way that payers and the industry and health systems have to address these issues. And so I was just curious to see if you had any updates on another hot topic, which is racial disparities and inequities in cancer care and outcomes. Is there any movement, traction, or anything that you could also bring to our attention as far as any movement in that space where we could I would love to work my way out of a job, where there's, comprehensive an approach to this instead of being so incremental within the system?
I think, fortunately, there are definitely efforts and a whole lot of attention on disparities, both in the cancer community and in the healthcare system as a whole. And I really hope that we get some more foundational movement in that area, really, in provider education around implicit bias and things that can make a huge difference in overall access to care, which would certainly have an impact on cancer care as well. I would say incremental versus, um, you know, big, bold legislation just doesn't seem possible in an evenly divided Congress. The Affordable Care Act is probably the last big piece of legislation we saw that had widespread impact in our healthcare system. In ways that people don't even realize, like providing grants to providers to go and work in rural areas and provide care. So I think that we're probably not going to see legislation like that until Congress has a little bit more movement, and Congress can't have movement when it's evenly divided.